Today, we will talk about how to file bankruptcy in Florida. Let's have a look at the details. When a person files for bankruptcy in Florida, they are seeking to get rid of or repay some or all of their debt while being protected by the U.S. bankruptcy courts. The most common forms of bankruptcy filings for individuals are Chapter 7 or Chapter 13. Chapter 7 involves liquidating certain assets to pay for your debt. Chapter 13 allows for the restructuring of debt so that a person can pay off his or her debt in installments. If you are unfamiliar with bankruptcy law, you should consult an attorney. The first step is considering the impact of a bankruptcy filing. Determine whether bankruptcy is necessary. When deciding whether to file for bankruptcy, it is important that you understand what debt bankruptcy will eliminate and what debt will remain. Consider student loans. As mentioned above, in most cases student loans will not be discharged through bankruptcy. If the majority of your debt is from student loans, Chapter 7 may not be a good choice. Consider impact on your credit. Before choosing bankruptcy, you should consider the impact that a bankruptcy filing will have on your credit. The second step is deciding what type of bankruptcy to file. Determine Chapter 7 eligibility. Chapter 7 bankruptcy is referred to as a liquidation. Chapter 7 may be best for individuals who are having difficulty paying their bills and are willing to sell or liquidate some of their assets to pay off their creditors. Determine Chapter 13 eligibility. Chapter 13 bankruptcy is typically best for individuals who have a regular income and want to restructure their debt so that they can pay it off in installments and discharge any debts left unpaid. Choose between Chapter 7 and Chapter 13 bankruptcy. If you find that you are eligible for both Chapter 7 and Chapter 13 bankruptcy, you should decide which filing best meets your needs. Hire an attorney. An experienced attorney can fill out all of the required forms, file the forms in the proper jurisdiction, help you choose the right type of bankruptcy filing, and fully explain your options and potential outcomes. The third step is satisfying pre-bankruptcy requirements. Complete credit counseling. All persons filing for Chapter 7 or 13 bankruptcy must complete a credit counseling program from an approved agency. Locate federal bankruptcy forms. All bankruptcy filers must use the appropriate federal bankruptcy forms. Locate the correct bankruptcy court. Federal bankruptcy courts are located throughout the United States. Determine relevant Florida exemptions. Each state sets forth its own exemptions for bankruptcy proceedings. Florida does not allow its residents to use federal bankruptcy exemptions, but rather a resident must use the Florida exemptions. The fourth step is drafting and filing bankruptcy documents. Complete petition. All filers for Chapter 7 or 13 bankruptcy must complete a voluntary petition for individuals filing for bankruptcy. Provide a summary of assets and liabilities. In addition to the petition, debtors must submit a summary of their assets and liabilities. Complete a statement of financial affairs. All filers must complete a statement of financial affairs. File a certificate of credit counseling. File the forms. Once you have completed the forms, you must take them to the appropriate bankruptcy court for filing. Check with your local court as to the filing fees, the number of copies you need, and any additional formatting questions. Thanks for watching this video. Please don't forget to like and subscribe to our channel if you like our videos.